Should the 50% reservation cap be raised? Why this is in news? Bihar's opposition leader has proposed increasing quotas to 85% if voted to power, while the Supreme Court has sought the center's response on creamy layer concept to the SCs and STs. These debates on reservation challenge the 50% constitutional cap and raise the concerns about the equitable distribution of benefits among the marginalized groups. What are the key provisions related to reservation in India? Reservation is form of positive discrimination, that is the form of positive discrimination aimed to promoting equality for marginalized groups, addressing social and historical injustices. That is positive discrimination aimed at promoting equality for marginalized groups and addressing social and historical injustices. It provides preferential treatment in education and employment to uplift the disadvantaged communities. At the central level, reservation include 27% for OBCs, 15% for SCs, 7.5% for STs, and 10% for EWS, making total about 59.5%. Through the share differs across the state as per the policies and demographics. The journey of reservation in 1950 and 51, commencement of the Constitution and First Amendment enabling the provisions in Article 15 and 16 for advancement of OBCs, SCs and STs. In 82, reservation for SCs and STs fixed at 15% and 7.5% respectively in central education institution and public sector undertakings. In 1990, the introduction of 27% reservation for OBCs in central government employment based on recommendation of Mandal Commission. In 2005, Article 15 inserted by 93rd Constitutional Amendment that enabled reservation for OBCs, SCs and STs in educational institutions and private ones. In 2019, Article 15(6) and 16(6) inserted by 103rd Constitutional Amendment Act, which enabled 10% reservation for EWS among the unreserved categories EWS in educational institutions and public employment. Key provisions. The Constitution of India incorporates various provisions to promote social justice and ensure adequate representation for historically disadvantaged communities. These provisions spans across Part 3 of Fundamental Rights and Part 16 of Special Provisions related to certain classes. Articles under Part 3 on reservation is Article 15(3) empowers the state to make special provision for women and children. 15(4) enables state to make special provision for advancement of socially educationally backward classes including SCs and STs. Article 15(5) allows reservation in educational institutions including private unaided institutions but excluding minority institutions for socially and educationally backward classes SCs and STs. Article 15(6) introduced via 103 Constitutional Amendment Act 2019 allows state to make special provision including reservation for economically weaker section, that is EWS, among unreserved categories. Article 16(4) permits reservation in appointments post for any backward class of citizen not adequately represented in the state service. Article 4A, which allows reservation in promotion for SCs and STs, that is 77th Amendment Act of 1995 modified by 85th Amendment Act of 2001 to include consequential seniority. In Article 16(4)(b) allows state to carry forward unfilled reserved vacancies from previous year without breaching 50% ceiling, that is 81st Amendment Act of 2000. Article 16(6) provides for reservation in public employment for EWS distinct from backward class reservation. Article under Part 16 on reservation. Article 330 and 332 provides for reservation of the seats in SCs and STs in Lok Sabha and state legislative assemblies. In Article 233T ensures reservation of seats of SCs and STs in every municipality. Article 243D mandates SCs and STs in every panchayat. Article 335 claims SCs and STs shall have to be taken into account in making the appointments to public services and posts consistent with the maintenance of administrative efficiency. Key judicial rulings shaping the reservation framework. In Balaji vs. State of Mysore 1962 case, Supreme Court held that reservations under Article 15 and 16 must be within reasonable limits, should not exceed 50%, viewing them exception to equality of opportunity, former equality. In State of Kerala vs. N.M. Thomas case 1975, Supreme Court recognized substantive equality, stating that reservations are not an exception but the extension of equality of opportunity. State of Punjab vs. Davinder Singh 2024, Supreme Court suggested that policies be framed for applying the creamy layer principle within SCs and STs reservation. However, the Union Cabinet clarified that creamy layer exclusion does not apply to SCs and STs. Not applied for SCs and ST and SCs quota. Landmark cases and judgment regarding the reservation. The case State of Madras vs. Champakam Doriarajan 1950, court ruled that caste-based reservation violates the Article 15(1) of the Constitution. It said reservation was an exception to equality, hence violated the right of equality, which led this judgment leads to the introduction of First Amendment Act of Constitution, which invalidated the judgment. Mr. M.R. Balaji versus State of Mysore 1963, the Mysore government 68% reservation in the college admissions was ruled in excessive and unreasonable, was capped at 50%. The Supreme Court in Indira Sawhney case imposed the 50% limit on reservation in 1992. Next, Devdasan versus Union of India in 1964, court ruled that if reservation go beyond 50%, they would be invalid. Reservation was rationalized and was termed a facet of equality. State of Kerala versus N.M. Thomas reaffirmed the idea of reservation is not exception but necessary to establish equality. It ruled that Article 16(1)'s conception of equality includes remedial action to ensure due representation and hitherto excluded classes. The ruling is considered to be the first definite judicial endorsement of the philosophy of reservation. Indira Sawhney and others versus Union of India 1992, the court upheld the separate reservation for OBCs but excluded creamy layer. It rejected economic reservation and set ceiling of 50% for all reservation. The case was pressed again in 1999. The Supreme Court reaffirmed the creamy layer exclusion and extended it to the SCs and STs. M. Nagaraj and others versus Union of India and others in 2007 upheld the 77th Amendment, which extended the reservation for promotion in employment of SCs and STs. The court ruled that promotion should satisfy the triple test, that is backwardness, second representation, Third, need for efficiency. Backlog vacancies were excluded from 50% limit. IR Coelho by LRS versus uh, State of Tamil Nadu in 2007. Tamil Nadu advised by Supreme Court to follow 50% reservation limit. Tamil Nadu reservations were put under the ninth schedule of the Constitution, which had already been upheld by the court. PA Inamdar versus State of Maharashtra. Reservation cannot be enforced on private educational institutions which do not receive government funding, which led 93rd constitutional amendment introduced Article 15(5). Ashok Kumar Thakur versus Union of India in 2007 upheld 93rd amendment on reservation for admission to unaided educational institution. Recommended reviews of backwardness every 10 years. Ram Singh and others versus Union of India in 2000 struck down the inclusion of Jats in central list of OBCs. Proposed new ways to determine the backwardness. Jayashree Lakshman Rao Patil versus Union of India in 2021 Maratha reservation struck down as unconstitutional. 50% ceiling on reservation was reaffirmed. Janhit Abhiyan versus Union of India in 2022 upheld the 103rd amendment, which introduced 10% reservation for educationally weaker section in education and public employment. A new reservation regime created. Formal equality versus substantive equality. Formal equality, that is principle of equality before law and equal protection of law under Article 14, ensuring identical treatment for all citizens regardless of caste, religion, socio-economic status. However, it may overlook historical disadvantages, systematic inequalities, potentially leading to unfair outcomes. Substantive equality focuses on achieving fair outcomes by addressing historical disadvantages and systematic inequalities. Focuses on achieving fair outcomes by addressing historical disadvantages and systematic inequalities. It goes beyond identical treatment, aiming to provide equitable opportunities and outcomes. Is reflected in policies like reservation. However, it requires differentiated support and implementation can be complex. What are the arguments for and against exceeding the 50% reservation cap? Demographic justification. Backward classes, that is OBCs, STs, SCs, constitute 60% of India's population. The current 50% ceiling limits the proportional representation. Second one is argument for 50% cap. The addressing unequal benefits. The Rohini Commission 2017 to 23 found 97% of OBC benefits go to 25% of subcastes. Raising quotas and introducing subcategorization. Could correct this imbalance. Rohini Commission. Promoting substantive equality. Supreme Court in State of Kerala versus N.M. Thomas in 1975 stated that reservations are a continuation of equality. Reservations are continuation of equality, not an exemption. Should not be limited by numerical caps. State level precedent. States like Tamil Nadu, Haryana, Maharashtra have implemented reservation beyond 50%, reflecting the need to adapt the policies to social realities. The argument against the exceeding the 50% reservation cap. Legal consent. In Supreme Court, Indra Samay case reaffirmed 50% ceiling to balance the merit and social justice, allowing exceptions only in extraordinary circumstances. Implementation challenges. 40 to 50% of reservation seats remain unfilled, indicating that raising quotas without improving implementation will not increase the representation. Creamy layer concern, as the Davinder Singh 2024 case emphasized, intra-caste inequalities within SCs and STs must be addressed. Expanding reservations without excluding the creamy layer would worsen the disparities. Intra-caste inequalities within SCs and STs must be addressed. Expanding reservations without excluding the creamy layer could worsen the disparities. Administrative efficiency. Raising quotas excessively could compromise excessively could compromise administrative efficiency by sidelining merit, potentially affecting the government. Excessively could compromise the administrative efficiency and sidelining meaning and potentially affecting the governance. What measures can be taken for effective implementation of reservation in India? Data on population, subcategorization and creamy layer, two-tier reservation for SCs and STs, address backlogs, skill development and employment. First, data on population. Undertake a comprehensive caste census to collect accurate data on population distribution and socio-economic status of various communities. Implement Rohini Commission recommendations and such subcategorization for OBCs. Consider creamy layer exclusion for SCs and STs to ensure equitable distribution within communities. Two-tier reservation for SCs and STs. Prioritize more marginalized sections before extending benefits to relatively better off members within these communities. Address backlogs. Focus on filling vacant reserve posts, improving administrative efficiency to make reservation policies effective. Complement reservation with training programs, job creation initiatives to meet the aspirations of India's large youth population. Conclusion. The reservation debate balances the formal equality, that is equal treatment, with substantive equality, correcting historical disadvantages. While exceeding the 50% cap is constitutionally sensitive, it reflects the demand for greater inclusion. Effective implementation requires data-driven policies, subcategorization, focus on marginalized group, complemented by skill development to ensure reservation empowers rather than exclude. Previous year question in 2023. Consider the following organization and bodies in India: the National Commission for Backward Classes, National Human Rights Commission, National Law Commission, National Consumer Disputes Redressal Commission. How many of the above are constitutional bodies? The answer is only one. That is National Commission for Backward Classes. One not second Constitutional Amendment Act and Article 338B